I express my gratitude to the committees and directors for the invitation to participate in the 7th edition of the International Conference on Critical Literacy and Educational Polyphony. I am Sandra Pérez, and today I present my research, Digital Image, Artificial Intelligence and Copyright. In this presentation, I will address an aspect that is intrinsic to both peace and ethical behavior: the respect for copyright within the virtual environments inhabited by the majority of the world's population. Following Professor Juan Martín Prada, the digital image is distinguished from photography or cinema because it exists independently of any physical matter before being converted into light. If we recall the history of these mediums, they traditionally relied on a chemical process. Essentially, the digital image is a sequence of mathematical operations, lines of binary code, or instructions to be decoded as an image. Digitalization implies simplification and synthesis into an algorithmic series operable by processors. The digital image is written, not inscribed. Its characteristics demand that we can no longer speak of an original image or possible copies. In the case of the digital image, it is more accurate to speak of an infinity of appearances or interpretations. This is because it is not a matter of seeing, but of visualizing or causing an image to be visualized through a screen, whose characteristics also influence that visualization. We have seen how each brand and model of mobile phone or computer presents a different version of a digital image. Every device will show a version according to its factory capabilities, settings, screen size, resolution, and calibration. Compression is another of its defining features, aiming to make the image lighter to increase its distribution or storage, a process that reduces redundant data and, of course, sacrifices quality and detail. Within the framework of intellectual property law, a work is understood as any original intellectual creation of an artistic, scientific, or literary nature, capable of being disclosed or reproduced in any form. Whether from the perspective of authors' rights, as in Europe and Latin America, where the creative act is prioritized, or within the Anglo-Saxon copyright system, which emphasizes intellectual effort, a work is defined as such because it reflects the creative choices of a human being. An idea is not a work, therefore it must be fixed in a tangible medium, whether material or digital, to be legally protected as such. All laws worldwide require the work to be a creation of the human spirit, that is, the author must be a natural person. In general terms, an author is the natural person who creates a literary, artistic, or scientific work. It is the individual who conceives the work and expresses it in a physical or intangible medium. Thus far, it is clear that our initial digital image can be protected under intellectual property law. Globally, the most important characteristic is that the author, by definition, is a human being or a natural person. This is based on the legal principle that machines and animals lack both a spirit and a creative will. Originality. To be considered an author, an individual must fill the work with their personality. This implies and highlights the importance of decision-making throughout the creative process. In respect to international law and global standards, The World Intellectual Property Organization is the international agency that harmonizes copyright laws globally through various treaties. The most significant is the Berne Convention, with which more than 181 countries are aligned. Adherence to this treaty implies the acceptance of automatic protection that is granted automatically, means that registration is not required for a work to belong to its author. National treatment, regardless of an author's nationality, when publishing in another country, they are granted the same authorship's rights under the laws of that host country. Minimum protection term. The minimum duration of protection is 50 years after the author's death, extended, for instance, to 70 years in the European Union and the United States. But what has happened regarding copyright in the age of AI? Let's see some examples. We start with the British artist Harold Cohen, who created a computer program called Aaron, based on an AI prototype capable of generating artistic works. Cohen began visiting the Artificial Intelligence Laboratory at Stanford University in 1971, which sparked his curiosity to explore new paths in art. Initially, Aaron learned image production from another robot. In its early stages, it was only capable of producing a few monochromatic lines, which Cohen would then complete to create figurative shapes and add color. After years of iteration and code improvements, Aaron evolved to generate human figures during the 80s and eventually began coloring the works autonomously in the 90s. Then the next Rembrandt is a project launched in 2016 that represents a substantial innovation in the creation of digital imagery. The project captured patterns for 3,046 of Rembrandt's works. This process involves more than just high-resolution scanning of the portraits themselves. It also encoded textures, brushes, and the physical thickness of the materials applied to the canvas. Using a 3D printer, a tool already used for creating other art reproductions, this team produced an entirely new work that met every aesthetic criterion of a potential Rembrandt painting. The final result respected in detail the original artist's brushwork and the specific depth of the layers of pigmented material. Later in 2018, Dr. Stephen Thaler, an entrepreneur and computer scientist, applied to the United States Copyright Office to register a work generated in 2012 by his AI system, Creativity Machine. The office denied the application, arguing that the human mind must be involved in a work of art to obtain copyright protection. The office's ruling was subsequently challenged in court, and the presiding judge also ruled in favor of the office. The court held that creations resulting from generative AI do not have copyright protection, as copyrights are granted to and limited only to human beings. Now, the case of Zarya of the Dawn. Kristina Kashtanova registered her graphic novel, which was entirely illustrated by AI. The Copyright Office subsequently noticed that this fact had not been declared by the author and initiated a revocation, means the cancellation of the registration process, although the artist argued that the work involved a significant creative process, including multiple iterations of prompts, various attempts at composition, selection, arrangement, cropping, and the editing of each image. It was decided in 2023 that the images could not be protected because they lacked a human author. This is an example of AI generation as a protectable work that was denied. In consequence, artists reclaimed their rights. In 2023, the first case of its kind emerged when a group of artists in the USA filed a multi-billion-dollar lawsuit against the company Stable Diffusion. They allege that the AI model was trained on their work without prior permission or negotiation, thereby violating their reserved rights as creators. The plaintiffs argue that everything generated by the AI consists of copies of copyrighted images. Consequently, they claim that every hybrid image produced is a derivative work. In response to this case, and directly working with one of these artists, the concept artist Carl Ortiz, in this photo, the University of Chicago has developed Glaze, an AI tool created in collaboration with artists. On the other hand, China has introduced the possibility of recognizing human intervention as a basis for granting copyright to a work. In the 2023 case of Li Junkai versus Liu Yuansheng, a Beijing court ruled that an image generated using Stable Diffusion was eligible for copyright protection. The court took into account the user's efforts toward aesthetic direction, noting that they selected the specific model, adjusted settings, refined prompts, and discarded multiple versions to achieve the final result. In India, artificial intelligence has been considered for co-authorship. In 2021, the Copyright Office of India granted registration to a painting titled Suryast, naming Ankit Sahni, human, and Raghav, an AI system, as a co-authors. For the first time, a non-human entity appeared in an official WIPO registry as an author, due to a broad interpretation of Indian law. Although the Indian office subsequently attempted to cancel the registration, the case had already gone viral. Consequently, a precedent was established in India suggesting that AI can be considered a subject of copyright. On the top of these cases, from a legal perspective, only human beings are subjects of law. Artificial intelligence can only be classified as a highly complex piece of tangible personal property. AI cannot hold any copyright to protect the outputs it generates. The term author is applicable exclusively to human beings. This is the same legal principle by which neither the painting pig nor the photographing macaque have been granted rights over their supposed works. Consequently, works created by animals other than human beings or by machines cannot be protected by copyright. While some scholars discuss the concept of the electronic person, such topics belong to the realm of post-humanist theory. And autonomy is one of the defining characteristics of a human being who creates a work. AI could only be considered autonomous if it were to dispense with human intervention and process supervision. However, this is a negative autonomy, as it does not emanate from within itself, unlike that of a human being. From a philosophical approach, AI can only emulate and simulate processes within the technical field, the corpus mechanicum. However, the animus vivendi, that is the intellectual conception, the sovereign decision of whether or not to bring a work into existence, and the creative will, remains outside the reach of any algorithmic programming. The volitional act of creation and the creative incentive are intrinsic and exclusive to the human condition. Although AI performs decision-making processes based on probabilistic modeling and pattern recognition, these operations are not equivalent to the human condition. AI calculates possibilities, whereas the human mind manifests intentions. Therefore, even though AI may generate images, paintings, photographs, and videos, this does not imply the presence of animus vivendi. These outputs are mere simulacra of art, devoid of the vital breath that connects a creator to their creation. Consequently, ethical and moral demands belong strictly to the behavior of subjects, not objects. An object cannot be held morally responsible, nor can it possess dignity in the Kantian sense. AI can only be granted rights and obligations of an instrumental nature, specifically designed to serve economic interest or mitigate civil liability, rather than recognizing any inherent personhood. We can conclude that the legal protection of creators in the age of AI must transcend economic interest to become a cornerstone of human rights and social peace under a critical approach. Respecting intellectual property is, at its core, an act of respecting the human dignity and the livelihood of those who contribute to our collective cultural heritage. A truly ethical implementation of artificial intelligence must prioritize a human-centric approach, ensuring that technology serves as a bridge for development rather than a tool for exploitation, by fostering a digital ecosystem based on transparency, consent, and fair remuneration. We promote a culture of peace, one that mitigates conflict between technology and labor, and protects the diversity of human expression against the risks of algorithmic homogenization. Therefore, our commitment must be to a future where innovation respects the fundamental rights of individuals. In doing so, we ensure that the digital revolution contributes to a more equitable and harmonious society, where the animus vivendi of the artist is not only preserved, but celebrated as an essential pillar of human progress. Thank you.